Also to my colleague, Dr. Freeman Yu, who will support me in the event there are specific technical questions relating to AI patents. Now, I will first start with the high-level objective. Right? My number one goal is to equip you within 1.5 hours, high-level knowledge and the type of skills that is needed in managing the protection and commercialization of AI innovation, specifically focusing in the digital space. Secondly, we'll be looking at best practices in a real-world context when you are involved in AI innovation projects or initiative. What are some of the real-world problems in relation to managing the intellectual property aspect, and more importantly, challenges and issues in relation to the commercialization. So the ultimate objective is to figure out the best way forward to create sustainable market value. So specifically, by the end of this program, you would have a clear understanding. How do you protect and manage AI innovation through the 4 basic types of intellectual property, right? Covering copyrights, patents, trade secret, and a little bit of trademark. In the second part of the program, we'll focus more on the go-to-market strategy, because at the end of the day, you can't deliver value, right, if you cannot create your ROI in terms of the AI investment that has been made. So the go-to-market program for the commercialization of AI innovation is critical in ensuring, right, that you have the returns on investment. Let me first start by giving you a strategic context. If you look at this figure shared by a firm called Ocean Tomo, right? The 90% of the S&P market value today lies in intangible asset. So can you imagine, right? If you're a company, if you're operating in most field, the likelihood of your intellectual capital being the biggest contributor to value is as real as it can get today. But if you look at the figure in 1975, intellectual asset and its contribution to market value was only 70%. But now it is the reverse, right? So intangible asset, which includes in what we're going to discuss today, AI innovation, AI patents, are all examples of a new type of asset class that is valued and treasured in industry today. So bear this in mind that as we go through the concept and the practice of AI innovation, especially AI patent, it can have a major impact on your bottom line, on your corporate performance, because the role of intellectual property to drive value cannot be questioned any longer. And this is the reality of the marketplace today. Now, if you look at the number of companies with the most AI patent, you will see that traditionally, software companies are the dominant player, right? In this list, you will see Microsoft, IBM, Google, but in it, you also have the device player, such as Samsung, Philips, Siemens, and so on and so forth, or Canon. The key thing to remember is, even though you may be a device company, the value of intellectual property, and especially AI patents, which we are going to discuss today, is critical in charting the direction of companies in today's digital economy. Now, in the topic that I'm going to cover, this is the basic terminology and the definition. Although there's some differences, right, in terms of what makes up AI and all that, I've chosen a simplified example. And for today's webinar, AI is broadly divided into two groups. So on the left-hand side, you see machine learning. Then on the right, you have natural language processing. Now, deep learning is a subset of machine learning. Then, of course, what underpins AI ultimately are algorithm. Now, on the right-hand side, I've adopted a basic chart on the definition of data science. You will see that it covers, among others, mathematics and statistics, process of data analysis, but it overlaps with machine learning as well as traditional software. Now, for today's webinar, we are going to focus on AI primarily as determined by the elements of machine learning and NLP. And I'll be giving you specific examples of how innovation in this particular space can be patented, and how do you monetize and how do you commercialize your innovation in this particular area. Now, a key point I wanted to share with all of you today is, at the end of the day, it is not a technical exercise. Now, you may be dealing with codes and algorithm, but at the end of the day, the determinant of commercial success is actually business strategy. Now, under business strategy, I've highlighted three key things. Number one, innovation strategy. Then number two, the growth strategy. Then third is intellectual capital strategy. Then within that particular broad ecosystem, AI technology is a subset of the domain that companies are now beginning to focus as part of their growth and innovation strategy. But for today's topic, we're going to cover intellectual capital in particular. Hence the topic of AI patent as an example of innovation that has to be protected, right, in different forms, including patents, copyright, and so on and so forth. Now, if you invest millions of dollars, or even at the government level, right, billions of dollars, it has to produce the right returns on investment. So the second half of the program will focus on the go-to-market technique, strategies, and how you can commercialize, right, your AI innovation that has already been protected. Now, very broadly speaking, this is the AI innovation lifecycle. You typically start with innovation at the top, roughly around 12 o'clock in the slide here, then followed by strategic business evaluation. Now, at the end of the day, AI innovation is not a technical exercise. It's primarily a strategic business exercise. You have to decide as an organization or as a company, how does AI innovation help you bring the company or the organization to the next level? So it's really a big business question rather than a technology question. Now, having said this, if you do not know the fundamentals of protecting AI innovation in the context of either patents or trade secrets or copyright, then you will not be able to capture its true value, and you will not be able to maximize the long-term commercial returns for the organization. So the strategic business consideration, therefore, is quite fundamental to your success. Then the rest of the steps, right, everything from invention disclosure, intellectual property protection, I think it's not that complex except for patent filing. That's the reason why I have my colleague here with me, Dr. Freeman Yu, who's my company's patent attorney, to help me, just in case some of you have any specific or very difficult questions that I can't answer. Now, having protected your innovation in the form of intellectual property, the next thing they got to do is to manage the intellectual property asset. You manage it by doing valuation, by doing audit. Then lastly, you focus on commercialization in order to secure the ROI. Now, so this is very broadly speaking, the AI innovation life cycle. I'm now going to focus a little bit deeper into the ways in which you can protect your AI innovation. Now, the easiest one is actually copyright. Now, the reason why it is the easiest is because you don't need to do anything. The minute you write your first line of codes, or the minute you choose an algorithm for your training model, whether it is a classical or ensemble type of algorithm, the minute you start to write the code and the minute you start to write the algorithm, it is already protected by law. Now, so copyright protection doesn't require registration or filing. It is automatically protected under the law. Hence, therefore, when you do AI innovation and you are focusing on the development of, for example, very sophisticated or advanced algorithm, that is automatically protected by the laws of copyright. Now, for patents, however, there is a very complex and a very technical process in order for you to protect AI in the form of a patent. So essentially, a patent is a monopoly. In return for your full disclosure of your invention, you will be given a certain number of period, typically 20 years, right, to have a monopoly on your AI invention. So a patent is very complicated. It's a bit more costly, and you need professional advisors, right? Professional team competent in the area of both the technology as well as the patent prosecution process. Patent prosecution process simply means the manner in which it is filed for the purpose of getting a patent to be granted. Now, the third form is trade secret. So essentially, if you want to keep your AI innovation as a trade secret, you cannot have the patent option. You cannot have both the patent option as well as trade secret, because for trade secret, you will not be disclosing your unique, for example, algorithm that you have developed or your unique process that you have developed. Now, trade secret, whether you choose trade secret versus patent, is a strategic business issue that organization must be involved in. Then lastly, you have trademark. After you've created the product, you want to create a brand around it. So that's where trademark comes in. That one you require specific filing, right? In Singapore's context at IPOS itself. So the purpose of trademark is to maintain your brand value through a logo, right? With a specific look and feel that would enhance your long-term brand value. Now, I'm going to go now a little bit deeper, right, into each of the specific areas. After the first part where I would have completed this high-level overview, we will be doing a short poll because for today, I obviously do not know the profile of our audience. So after this high-level overview, we will do 2 polls. Then I will have a very clear idea. What is the profile of our audience today? Now, moving on, I want to go a little bit deeper on the specifics of intellectual property protection. Now, when you innovate in the AI space, you're primarily developing codes and algorithm. Now, the law of copyright works in such a way that it only protects the expression of ideas, but not the idea itself, right? So if you have an idea, you think about it conceptually, the law doesn't protect your ideas at that level. But as soon as you codify or you write it out, the law protects what you have expressed. So this is the term that they use. Copyright protects the expression of idea, but not the idea itself. Now, so the minute you write your first line of code, right, or when you start to develop your algorithm, you are automatically protected. So there's no need for registration. There's no need for filing. Then, of course, if you want to demonstrate that you own the copyrighted materials in the form of source code or your algorithm, there are different ways in which you can manage that, which we can go into a bit more detail later. Now, so for AI innovation, source code and the algorithm are automatically protected by copyright. Then lastly, of course, when you compile data in any unique way, which is original, copyright law also protect the compilation of data, but not the data itself, right? Okay, so if you amass millions and millions of huge volume of the data points, you can't have copyright to the actual data, right? Specific data, but you can have copyright protection for the way in which you compile the data. Now, so the way you compile the data has to be expressed in a certain way. So the law of copyright protects expression of ideas. Now, so in the AI innovation context, that expression of idea can be done in many forms. Paper form, when you write out your invention. Then when you write out your write your codes, those are examples of ideas that are expressed. So copyright protection is fairly easy. The rights arises automatically. Now, for patent, however, it's a little bit more complicated, right? When you have a unique invention, right, and you want to patent it, it must fulfill the requirements based on the patent law of a specific country, right? All patent laws, like all copyright laws, they are territorial in nature. So AI innovation that are protected by patents in Singapore would have to be governed by patent laws in Singapore. Likewise, if you're in China, it'll be bound by the laws in China and at the US and so on and so forth. So the word we use in that context is the law is territorial, right? It is specific to a jurisdiction. Now, in this example that I'm sharing with you now, this is the requirement in Singapore. Your AI innovation has to be novel, right? So this invention must not be previously made known to the public anywhere in the world, right? Okay. So if by chance you think you have something new today, turns out that someone else have developed it in a laboratory somewhere in the US, that will mean that your invention is no longer novel. So a requirement under the law is it has to be something not previously made known to the public anywhere in the world. Now, second, there has to be an inventive step. It has to be an improvement either in terms of the product or the process. Now, the whole idea of AI innovation is to create something new or different, right? So it should be an invention, right? So it has to represent an improvement over either a product or a process, right? Okay, then lastly, whatever you develop must be capable of industrial application. So this is a practical test in terms of the eligibility, right? We call it patent eligibility, that in order for it to meet the requirement of patentability, it has to be one which can lead to industrial application. Now, these are all the broad requirements of patenting a product or a service in Singapore. But across the world, largely the principles are unchanged. There are some differences, there are some critical differences, but in Singapore, these are the basic requirements. So a key point to remember is when algorithm and source code are automatically protected by the laws of copyright, for patent filing, it doesn't work that way. Now, so algorithm in itself, right, is not patentable. And one of the key, most important thing that when you file a particular patent is it has to demonstrate some form of technical effect. So meaning to say that if you only do software algorithm, you do software development, and you only create algorithm in itself or algorithm per se is not patentable. So it has to be combined, right? It has to be combined with physical processes. It has got to have technical effect. And I'm now going to give you one example. Now, this is example cited by our intellectual property office of an AI patent that was granted to Crimson Logic. Now, it basically has to do with codes, right? The HS code, which stands for the Harmonized System for the International Classification of Goods. So what Crimson Logic did, right, was they developed a software, right, that allows the user to simply input the product description in layperson language, something that they're very familiar with, but they were able then to retrieve the most appropriate harmonized system code, which is called the HS code, based on the recommendation of the software engine. Now, it may look to you like, what's the big deal about this? But there is an inventive step. There is clearly something novel that not been done before. So you will notice that in the note here shared by IPOS, the Intellectual Property Office of Singapore, Crimson Logic's search engine uses, right, neural network, right? That's most important. It uses neural network to make the code, the harmonized system code recommendation based on historical data, right? Now, so the use of neural network is an example of deep learning, right? And in the context of AI innovation, this is how AI can be protected by the laws of by patent law. Now, in the Crimson Logic example, they also use traditional technique, right, such as machine learning, NLP, which is natural language processing. Then, of course, they use traditional exploratory data analysis. Now, as you can see here, the patent was granted. It is primarily related to a neural network driven by their unique search engine software that they have developed. So the combination of all this enable them to qualify for their innovation to be granted a patent. Now, if you look at the bottom here, how they make the money is they then incorporated or embed, right, their AI innovation, which is patented, into their product offering. So this is an example of how once the innovation, the invention has been done, once the algorithm, right, for their search engine has been developed through machine learning and NLP, among others, it is then embedded into their product, right? And the best part is here, the product can be used in any parts of the world. So it has definitely industrial application. It is novel, right? And it is clearly an inventive step. Because previously, without this AI innovation that they have developed, it's a bit more difficult, right? It's more cumbersome. So by innovating in the area of AI, just focusing on a simple process of trying to make it easier for someone to find the relevant international classification of goods, you can have a patent granted. Now, I have another example here of a US patent. If you review any patent grant, the first thing you read, of course, is the abstract. So you'll notice here in the abstract that I have here, it basically summarizes this as an AI system, right? Okay, although the description here is a bit, may sound a little bit more generic. It's a form of innovation, which I will not be going into the detail. But I wanted just to share with you that so long as you meet those criteria that I've highlighted earlier, it becomes patent eligible. When it becomes patent eligible, you therefore would be able to file for patent. So typically in Singapore, the Singapore government have been trying for many years, right, to shorten the patent filing process. So typically it could be like 4 to 6 years, in some countries much even longer than that. But the Singapore government have been attempting for a couple of years now to be among the first few countries in the world to shorten the patent registration process as short as possible to a number of years. But bear in mind that patent filing can be quite costly, right? As opposed to, for example, copyright, where there is actually literally no cost at all, because the protection arises automatically. Now, the third method of protecting your AI innovation is what we call trade secret and confidential information. Now, when you have an application for a patent, you must disclose your invention so that someone who has got ordinary skills in that particular domain will be able to replicate. So in return for your full disclosure, you get a monopoly, right? So it's protection and a monopoly for 20 years from the date of filing. Now, for trade secrets and confidential information, it's another strategy, but it is completely the opposite. So in this instance, what you do is you keep it strictly confidential and you manage it, right, in the form of, under the law, we call it a trade secret. So there are many ways in which you can do this. You need the proper documentation, you need agreements such as non-disclosure agreement. You got to secure your innovation under lock and key. There's so many ways of doing this, but you must take steps to clearly indicate that the innovation that you have developed is considered by the creator and by the owner of the innovation, which is the company or the research institution. It must be expressly written out as a trade secret. Now, so trade secrets versus patent filing are completely different approaches to managing your intellectual property asset. Which brings me now in the next slide. What is the overall game plan that you need to be aware of? Now, in this short program, I have focused so far on the high-level description of types of intellectual property, right? And the issues and challenges in the context of protecting AI innovation, which are primarily, right, source code and algorithm, right? Now, in this next section, I want to start to focus on commercialization, right? Before we end the first part of the webinar. Now, for commercialization, it basically means that whatever you have invested in terms of the inventive steps or the unique AI processes, we are talking now about the go-to-market approach. So typically when organizations get involved, they shouldn't be focusing on the innovation first without first doing a market analysis. So typically when organizations get involved in trying to determine AI as a value driver, it must start with the business strategy. It cannot start in any other way except by you determining what is the kind of commercial outcome you want to achieve. So in order to do this, organizations typically carry out what we call this technical term, right, called prior art searches. So what it basically means is you have to carry out searches to figure out that no one else have done this, no one else have developed or created this solution. So this is what we call prior art searches, because the rule for patent filing is if someone else have developed it or created it, you cannot claim a patent for it, because the rule of thumb is if it's been created or invented elsewhere, it doesn't qualify your invention to be registered as a patent. So we call the term we use in industry is prior art searches. Now, related to prior art searches is a term which is often used in our industry, my industry. We call it technology intelligence. What it basically means is more or less the same. You try to figure out who's doing what and whether the space that you want to go into is the area in which it will give you strategic competitive advantage. So the first step, therefore, in ensuring that you meet this minimum requirement of ensuring proper commercialization, you must start with the business strategy. So as I mentioned earlier, business strategy covers, among others, your growth strategy, right? Your growth strategy, your innovation strategy, and most important, your intellectual capital strategy. Now, why is intellectual capital strategy key? It's because data have shown that what makes a company valuable today, in accordance with the S&P 500, right, the market value, intellectual asset now is the dominant type of asset, 90%. Now, in order for you to be able to maximize the returns on technology or AI innovation, you must start first by identifying the market needs. So the key, therefore, to success in commercializing AI innovation is you must start with the demand of the marketplace. What kind of problem has your AI innovation, is your AI innovation going to solve? What kind of value is it going to create? Is there a large market share? So these are all commercial questions, which I will be going through a little bit more detail after the poll question. Now, the process of patent application is very complex. It's very technical, and it's much more costly. Right. So, for example, for myself, when I found my own AI patent, I spent just under 30,000. Right. So it's not small money, but it's not like you have to spend. But some companies spend millions of dollars, right? Especially for the large organization. Now, when you therefore talk about what does it take to be successful in commercialization, the answer is you must understand the needs of the marketplace. So having a clear idea how you're going to help solve problem in the industry, how you're going to add value, who's prepared to pay what and how much for your AI innovation is going to be a critical part of your success, right? In order for you to be successful in AI commercialization. Then lastly, for the commercialization technique, there are many ways in which you can monetize your AI innovation. First, you can sell the asset, in which you get returns in terms of the monetary return, or you could license it, right? It could be annual subscription, it could be one-off, upload front loading in terms of the amount that you have to pay, and so on and so forth. Then lastly, of course, there are other ways in which, okay, hang on, my colleague is just making sure that the sound. Yeah, sorry, my colleague's handphone was ringing. Sorry about that. Yeah, okay. So the last bit I wanted to finish up is the commercialization strategy requires that you take a market-driven approach. Okay, then lastly, before I end this first part of the session, I want to emphasize a few key points. Okay, number one, AI innovation strategy must be aligned with your overall business strategy. Now, commercial value creation is often the most difficult part of the business. Surely, if you speak to researchers and innovators, right, writing the algorithm itself can be a very complicated exercise. But at the end of the day, no matter how complicated or how advanced your algorithm is, in order for you to innovate in the area of AI, ultimately, commercial value creation is about whether the market is prepared to pay a price to use or to license the technology from you. A third point to highlight is you must take a market-driven approach in AI innovation in order to help solve problems or add value. Then lastly, whatever you do, AI innovation must ultimately lead to returns on investment. Okay, so with this, I'm going to end the first part of the session. We are now going to do a poll, right? And the reason why I am doing this poll is I want to get an understanding from the around 70 of you, or just around 60, 69 or 68 of you today, right? Whether the group that is present here today are primarily in the data and AI space. Now, so the poll question had been put up. Can you now just answer yes or no to the following question? Are you involved in any form of AI design and development? Right. So if you could fill in your poll result now, please. So I have an idea the percentage of the audience today who are involved in AI design and development. So I think Michelle, who is from the Smart Nation office, Michelle, will we be showing the result together for question 1 and 2, or we're going to do it separately?
Just give me a moment.
Yeah.
So I think we'll do it separately.
Yeah. Okay. So let's now see the result for question number 1.
Just share my screen, maybe.
All right. Great. Great. So it's going to help me to know whether our audience today is primarily a technical audience, which I'm expecting it to be the case. So while Michelle show us the result of poll number 1, also take a look at poll question number 2, so that I have an idea the percentage of you today who have knowledge and skills relating to IP management. So Misha, should I stop share my own screen or?
It's okay. I think I'll just type out the percentage in the chat box. I think that's
Okay, okay.
yeah.
So let me see. Oh, you're not going to show the screenshot of the.
Yeah, I'll just share the percentage.
Okay,
So for
great.
now,
Okay, great. I'll wait for the result first. Okay, to one, I have a question whether we will be posting it. We'll get the slide and all that. It'll be posted on the YouTube site for the Singapore, the Smart Office and Digital Government Office. Okay, Michelle, not there yet, right, Michelle?
yeah. So maybe I can just go to question 2 first. So
Okay, great.
For question 2, I think 84% of our participants actually indicated that they do not have any knowledge, skills, or experience in IP management, and 16% have. So yeah, the majority do not have.
Okay, got it.
Yeah. So I think for question 1, I'm still trying to pull out the answers, but again, majority are actually not well versed in AI as well. Or not involved in any form of AI design.
Oh, I see.
That is the answer.
See.
Yeah.
Okay, I was actually anticipating a crowd which is predominantly technical. But it appears that is okay. Good. I now have a clear idea. Okay, so 84% of you, right? 84% of you today, right? Have indicated that. Let me just. 80% have indicated that you do not have knowledge or skills in the area of intellectual property. So I will therefore focus on this. Now, to your first question, to my first question, the answer is, what was the percentage again? To question number 1 again, Michelle?
It was about 60% who are not involved.
Okay, great. I now have an idea, right? I now have an idea in terms of the audience. So it's not fully technical, but 60% is quite still, that means approximately half, right? Approximately half are not involved in AI actual related type of innovation. Now, for the second question, the majority of you do not have experience in intellectual property management. Okay, great. Now that I have a fairly clear idea, I am now going to attempt to answer the questions, right, that has been posed in the chat function. I'm going to go now to the first question. Hang on, right? So the first question is, Crimson Logic AI patent is covered in Singapore. Isn't there likelihood that the IP be duplicated overseas since the patent is not covered there, right? Okay, now, the way it works for patents that are filed in Singapore, the first step that all AI innovators do is they file the patent in the country or in the geography that matters most to the organization. So in this instance, if you're a Singapore-based company, you must start with Singapore. However, under the World Intellectual Property Organization framework, you can file your patent in many other countries through a simplified process known as the PCT, which stands for the Patent Cooperation Treaty. So the answer to Lena Monica Ali's question is, when the patent is filed in Singapore, by virtue of the fact that they would try to patent it in other key market, they would be protected. So if Crimson Logic do not, just give you a hypothetical example, do not protect their patent in Indonesia, just as a hypothetical example, then they will not be protected there, right? They will not be protected there at all. So I hope Lena, Monica Ali, I hope I've answered your question. Now, the second question is, appreciate some example of what is meant by AI algorithm. Now, algorithm are simply codes or instruction, a set of rules, right? Basically expressed in a particular code form that is the result of codes being developed to match the requirement of the domain expert. Okay, so to your question, what is meant by AI algorithm, right? Now, I would share back my slide. Maybe I can do that now again. What do you mean by AI algorithm? I will just share with you.
Yeah, maybe Zayed, apologies, I just jump in at this moment. So yeah, so for question 1, I think I'm currently sharing the results. So actually, yeah, I made a mistake. It was actually 87% of people who are not involved in any form of AI design and development.
I see.
So what you're sharing is quite new to us all. Yeah.
Okay, great. Now that I know the makeup, right? Okay, so I'm going to answer now one of the earlier question, which is, okay, can you show us? Okay, hang on, let me just close my screen again. I'm trying to get back to my main screen. Okay, sorry, this is not what I want to show. Okay, let me go back to my screen again. Okay, I will try to answer now one of the question that have been asked. Okay, so let me just now share my screen again. Okay, so the question is, can I show examples of an AI algorithm? Okay, there is no unique distinction about AI algorithm versus non-AI algorithm. The only difference is when one talks about AI, we are talking about source code and algorithm for the purpose of deploying two techniques, right? Machine learning technique, then secondly, NLP, which is natural language processing. So the method with which you develop the source code, right? Source code, and the method with which you develop the algorithm, so long as it is for the purpose of deploying this technique called machine learning and NLP, right? In the context of the definition of AI, it meets the broad definition of AI algorithm. But is there a difference between AI algorithm and normal algorithm used in software development? The answer is no, right? Okay, if you look at the slide on the right-hand side, you notice that I covered, among others, computer science, traditional software, and then it overlaps with machine learning as well as traditional data analysis. Now, so if you therefore understand that traditional types of software programming is actually no different in the compared to what is nowadays called, right, specific codes for the purpose of machine learning. So typically within the industry, we have seen, right, a machine learning engineer having a different role compared to traditional software engineer, right? Okay, so in the IT field, the requirements are a little bit different, right? You have to amass huge amount of data in order to create what we call a training model. When you create, when you have data set, in order for you to be able to train, you create models, right? Okay, so machine learning models are example of AI software that has been developed specifically using the technique of machine learning. Now, if you use techniques such as machine learning for NLP, right? NLP basically is a textual analytics technique that relies more on textual data, right? Textual data. Now, so textual data comes in the form of words, right? Come from word. So natural language processing essentially revolves around the technique where you focus on textual data, where you look at things such as, words, phrases, context, and so on and so forth. So when you use NLP technique, and especially when you use machine learning technique for NLP, this is today generally regarded as AI algorithm, right? AI software. Now you will notice in my slide here, I have deep learning. Now, deep learning is a subset of machine learning. Now, the only difference between deep learning and machine learning is deep learning are very advanced software that mimics the way the human brain function, right? So it essentially revolves around what we call artificial neural network, or ANN. Now, at the end of the day, everything else will revolve around codes and algorithm. And that's my answer to the question I think posed by anonymous attendee. Okay, so I've answered two questions so far. I'm now going to look at the third question by Jake. The question by Jake is, does AI algorithm need to be integrated with hardware to be patentable, or can it be integrated in software as well? Now, I will ask my colleague, Dr. Freeman Yu, who is a patent attorney, to support me in my answer to this particular question. So for those of you who came in a little bit late, right? Dr. Freeman Yu is a patent attorney. He runs a firm called Synergy IP, who files patent globally, including AI patent. Freeman, I will answer this question first. If you could supplement, Freeman, my answer to Jake, right? Okay, so Jake Lai, the answer to your question is, if you have software such as an AI machine learning algorithm, right, that is integrated with hardware that can produce a unique outcome or output in terms of the product or the process, then the chances of being granted a patent AI is much higher, right? Much higher. Now, if you only have AI algorithm to be integrated with other types of software, the answer is it depends on the specific product. So if you look at the Crimson Logic example, right, they created an engine that is able to provide solution in the context of someone trying to find the most relevant international classification code for this, right? So essentially, at the end of the day, there is no hardware, right? There is no hardware involved in it. And in that case, it actually integrates, right, the use of a neural network in the context of basic techniques such as machine learning and NLP. Now, let me just show you the slide so that we have a clear idea of the AI patent for Crimson Logic. Okay, now, so Jake, I hope I've answered your question. Freeman, can I invite you, Freeman, to supplement what I have shared so far? Freeman?
Okay, can you hear me?
Yes, we can hear you now.
Okay, good.
Can you show your video also, Freeman, or you can't show your video?
Is it my very handsome to look at it? Okay, let me turn it on. Okay, can I turn it on?
Turn on so that they see who you are. It's better for communication, Freeman.
Okay, can you see me now?
We can see you. We can see you and we can hear you clearly.
Okay.
So go ahead, Freeman, to add on to my response to Jake Lai.
Okay, I made my answer short. It's basically whether software patentable is assessed by whether it has technical effect. These criteria set by European Patent Office, well accepted by other major patent offices such as US, China, Singapore, all those patent offices accept this criteria. Now, what is something has a technical effect in terms using layman's language, basically meaning does your algorithm or software, particular software, have any influence to the physical world as we are living? Or conversely speaking, is your algorithm or software, it's a merely replicating a mental action of a human being? I give you an example. So if I design a software, maybe every day look at the stock exchange of Singapore stock, all the stock prices, then by the end of the day, it does just use the Excel sheet. Of course, the software does automatically calculate how much each share rise percentage give me the result. Now, this software most likely is unpatentable because it's basically replicate my mental action. Theoretically, I can use a piece of pencil and pen, do the mental calculation myself. What the computer does, it's just generic use of a computer. Of course, it does the job faster, but essentially it's still a mental action. So in this sense, this kind of software is not patentable. But if I develop a software using the neural network, every day study the Singapore Stock Exchange, learning the rise and move up and down during the past 10 years, the neural network, after learning, maybe taking the news from the media, newspaper or online sources, then it predicts, say, next day, a particular stock is going to rise how much cents, how much dollars. Then this kind of software is likely to be patentable because it uses a neural network to involve the machine learning. So this is once a neural network involved, the patent office around the world will accept this is it's not mental action. Human brain cannot just replicate this kind of action. So in this sense, it's patentable. So if you just say a particular software patentable or not, so the easy answer, it depends. Yeah.
Okay, so Freeman, thanks very much. I will now answer another question from HB Ong, right? So the question is there any significant difference between machine learning under data science versus machine learning under AI? So that's an easy question. Okay, Ong, that's an easy question. The reason why I say it's an easy question is it's just a matter of terminology. So in the reality of the way the industry function today, sometimes data science is equated with AI. That's not correct, right? So what I've done is in this slide that you can see now, I make a distinction between two broad disciplines, right? But does it overlap? The answer is yes. Now, so AI has been around for 60 years too, right? Likewise for data science, right? They've been around for, it's just that today is much more advanced. So to your question, is there any difference in terms of between machine learning under data science versus machine learning under AI? It's actually the same, right? So HBong, the answer is it's exactly the same. Now, if you can see the slide that I've shared here with you, here, if I can just use my pointer here, right? Okay, let me just show you my pointer. Okay, my laser pointer. As you can see here, there's machine learning under data science. There's also machine learning under AI. This is just for convenience. So for the purpose of this short course that we have, it is the same. Okay, so I've more or less answered all the questions that have been asked so far. So what I'm going to do now is I'm going to continue with a little bit more detail. It's already 1:05, almost 1:10. If you have any further question to myself or Dr. Freeman, please provide your question in the question and answer format. I believe I have answered all the questions so far. Okay, so what I'm going to do next, right, is I'm going to cover a little bit more detail in terms of the additional points that I wanted to share before we go into the feedback and so on and so forth. So I'm going to share with you a little bit more in terms of the details. Okay, so the copy of the slide, as you know, right, will be made available online, right, online on the YouTube channel for the Smart Nation and Digital Government Office. In the first page of the slide that I share, you will find my email address. You can also write to me directly later if you want a copy of the slide. Now, I'm going to go into the last bit of our exercise, basically for the last 10 minutes or so, right? To go into a bit more detail. And now, I know now that 87% of you do not have any direct experience in data and AI project. I also now know that 84% of you today, right, are from the 60 plus that is present here today, right, do not have experience in managing AI. So what I'm going to do now is I'm going to go a little bit deeper, right, to just in the last 10 minutes or so, right, for me to cover some of the issues that I have not covered in part one, right? So part one essentially covers the high level, the key points, right? To give you a bird's eye view of the area that we're talking about. Now for part two, we're going to go a little bit more detail. Then I'm just going to walk through only some of the key points, not all of the key points which you contain in the slide. Now, one of the issues that I wanted to highlight is when you develop AI solution in the context of AI innovation, bear in mind one major difficulty, which is the issue of transparency, right? The issue of explainability of algorithm. Whether when you develop the algorithm, it has taken into account issues of fairness, the avoidance of bias, and so on and so forth. So the one big difference between AI innovation and innovation in general, especially when it deals with specific product, is because the AI space is primarily dealing with software. In the context of, for example, when you develop machine learning models based, for example, on unsupervised machine learning technique, right? There is a possibility that even the developer do not know, right, how the final output was developed, right? Okay, so when it comes to supervised machine learning, it simply means that the human domain expert provide the input or what we call the parameter or the variable to enable the software, the machine learning engineer, right, or the data scientist who write the code to translate a business requirement into in code form. So one of the big problems that we will face in industry today, right, is because AI algorithm can be very complicated. Issues relating to explainability, transparency, and bias becomes an issue. So just bear this in mind that this is a unique dimension in AI innovation that has got to be managed. Now, in this slide number 21, right, what I've done is I've summarized the detail, right, commercial question. Now, this short webinar, which is a prelude to my actual course, which is what I'm running at the NUS Advanced Computing for Executive program called ACE, right? We will go into a bit more detail, right? The program is a 6-day program. We'll go through a bit more in terms of the detail. Now, these are all examples of the type of commercialization issues that must be addressed. So if you are an innovator and you are not a technical person, you can still do AI innovation. I always share this with my students as well as my industry practitioners who are my trainees, right? That the way to develop AI innovation, you don't start with a technical process. You must start with a non-technical approach. What is the problem that you are trying to solve? How has your new technique, right, or solution, how is it helping to solve the problem in a better way, right? Does it have industrial application, as in people can use your software, right? So what do you think the market reaction will be to your product? These are the commercial opportunities. Which countries in which is likely to have the highest, right, a positive response to your product? So these are all examples of the types of commercial questions that you need to address. Then lastly, I want to focus now on one final element, which is on commercialization technique before I finish off the section. Now, after you have done your AI innovation, the first thing you got to do is you got to protect it in terms of your either patent, trade secret, or copyright. Copyright, you don't have to do anything. For trade secret, you must do something. For patents, you must file, right? You must file, and the process can take a few months to draft the statement of claim, for your patent and so on. So the process is very detailed, can be very complex. Now, after you've done all that, which is understand the market needs, understand the market requirement, etc., etc., you then go into the last and final stage, which is the techniques for commercialization. So in the course that I will be going into, 1/3 of the course will cover commercialization technique. So you can sell your intellectual property, right? Of course, you can sell your technology too, right? So if the technology and the intellectual property is combined into one, then you only have one product. But if your product is split into the technology versus the IP, then you may have a different scenario where you can sell the IP, but the product is a different thing altogether. So techniques in commercialization include things like the sale of your intellectual property. When you sell something, you give it away, right? Now, license means you own the technology, you own the intellectual property, but you permit someone to use it. So this is what we call intellectual property licensing, right? Licensing. Now, of course, you have the end user. Sometimes you may have a strategic account where you license it to be used by a major operator at the server side, for example. I would call this as strategic licensing. End user licensing simply means that the end user, such as the consumer, who use your product will ultimately be the one to make use of your technology. Then there are three techniques, right? You can enter into a joint venture where your AI innovation is put in as part of your capital injection. So instead of putting in money, you can go into a venture whereby your patented AI or your copyrighted AI is actually provided as part of the capital of the company. So in a typical joint venture where you capitalize your IP, it basically means that the asset that you have will be injected into the company's asset when you create a joint venture company. Now, so this is the technique that is typically used in the context of a joint venture. Then lastly, of course, you have distributors and resellers. You work with such partners in order to scale your business. Now, in terms of pricing, there are many models out there. There are fixed pricing, then there are variable pricing, and so on. So this will be the details that we will be going through throughout the course when we if you take up the course that I have. Then lastly, in the last 5 minutes, these are the typical issues that you need to consider, right? In terms of the commercialization. First, you have to think of documentation. When you enter into a distributorship agreement, there has to be documentation. Second, most important, there has to be a marketplace, right? So depending on the model that you choose, it could be a marketplace model, it could be a distributorship model, there are different models. Then lastly, of course, you have to negotiate the terms and conditions. And we, in the course, we will be going a little bit more deeply into how you create licensing structure, how you negotiate the deal. In some cases, you may have royalty and so on and so forth. Now, lastly, these are all examples of legal agreement, right? Legal agreement that has to be prepared in the context of your entire end-to-end AI innovation life cycle. So with this, I just want to let you know that the 6-day course will be run by the NUS School of Computing, which I am associated under the executive program, right? The Advanced Computing for Executive program called ACE. So at ACE, we will run this 6-day program, and you will get a copy, right? After you end this particular program, you will get a certificate in the form of a professional certificate. Now, so this is a 6-day course. There is funding of up to 90%, and the email address is there, right? So when you go through the video and so on and so forth, you can take a look at it. Now, this will be I think May will also be sharing those links with you at the chat function, right? The details of the link. But what I want to do now is to invite you to help us by participating in this video. In the last 10 minutes, I hope you can help our Smart Nation office in Singapore in particular, who is the main organizer for this particular program. Please scan the QR code or go to the link that will be provided in the chat function. Please key in, please help us with the feedback today, right? We really would value your feedback. And while you do that, I am going to check whether there's any further question in the question and answer session. Okay, so Josephine Ong, question: are there any prerequisite for the program or the course? The answer is no, right? This program that I have developed specifically focusing on 3 things. The first is divided into 3 components. The first component is the AI innovation value chain. The second component is methods to protect. We'll go into detail on copyright, patent, filing requirements, and so on. So it's, this 1 hour program, 1 hour plus program is spent only designed to give you an overview. Then the third part of the program is on commercialization. So to answer your question, there is definitely no prerequisite for anyone to attend the particular program that I am going to conduct. And the date, as I've indicated earlier, it will run in November for a 6-day program. Okay, so please help us by filling in your feedback to today's session.